opposition is prepared to support it.
I call David Clendon.
Thank you, Mr Speaker. Mr Speaker, I'm pleased to take a short call on this Juries Amendment Bill. I think we'd all agree that the basic principle of using juries doesn't need defending. The idea of a panel of one's peers sitting in judgment or consideration of one's innocence or otherwise has got a very long history. It's well established, well respected, and I think that certainly participation in jury service is an expression of our rights and indeed our responsibilities. It's a form of civil engagement in civil society that I think is valuable and entirely valid. This bill does make some relatively minor amendments, but it does make one or two useful amendments as well. And for the third time this evening, the Greens will be supporting this government measure, which might cause some members of the government to go and have a lie down and get over it. But I assure you by Thursday normal service will be resumed. We will be critiquing the government's budget very vigorously as something for you to look forward to. More seriously, Mr Speaker, we do see value in some of the provisions of this bill. It seeks to protect to some extent the integrity, or at least the perception of the integrity of the jury system, to the extent that it does either exclude or defer some participation, and it looks at issues around the potential for people to be excused either temporarily or indeed permanently. The question of disqualifying a person who has been subject to a period of home detention of some 3 months or longer did give us some reason to consider that fairly carefully. But on balance, we see that this actually does bring this provision brings in line people on home detention with those who have a custodial sentence. And in that sense, given that since 1981, I think, when the Juries Act, the Substantive Act, was enacted, home detention was much less commonly used. We do use it now in forms and for reasons that formerly might have attracted a custodial sentence. So that provision would seem sensible, and it brings non-custodial home detention sentences more in line with custodial sentences in this context. And that would seem to be a reasonable thing to do. Equally, allowing for a jury service to be deferred for a person who is currently serving a sentence of home detention of 3 months or indeed up to 3 months, again seems sensible. And I don't necessarily think that a person serving a sentence of home detention would not be a fit and proper person to sit on a jury. We absolutely oppose, in principle, denying rights, normal democratic participatory rights to people simply because they are inmates, which is why we did actively and vigorously oppose the very poor piece of law that was passed, I think, earlier this year or late last year, that denied all prisoners the right to vote. That was a retrograde step, and one which we continue to regret. In this instance, however, the idea of deferring participation of a person on a short home detention sentence, I think, is more about the perception. There could be public unease at the thought of somebody currently serving a sentence also sitting on a jury at the same time, and I think we need to respect that, and so on balance, we have no particular difficulty with that bill, given that that person at the completion of their 3-month sentence does have the right and again the responsibility to attend a jury, to sit on a jury, to participate. The bill allows for the permanent excusal, the new word has been used and I'll adopt it, I'm not sure it is a real word, of people by reasons of chronic ill health, disability, or for people over the age of 65. And we're aware that this excited quite a lot of opposition, in particular the question of the age of 65 being a point at which people could choose to permanently excuse themselves from jury service. Different organisations and individuals suggested it was ageist, said it was paternalistic, said it was excluding an increasingly important demographic, but I think the key to it is that it's a voluntary thing. We would utterly resist any imposition of a barrier to participation in juries on the basis of age or disability or illness. But in this instance, it is a voluntary thing. And it's fair to say that for some people with severe disabilities, it could be extremely difficult for them to participate actively in a jury, and they ought to have the right to be excused. But certainly I think we have to take care that this provision to allow for permanent excusal does not somehow morph into an expectation that we need not provide for the possibility that people with disabilities, for example, might choose to actively participate. We must always be alert to the fact that a person has a disability must not in any way exclude them from taking the choice to participate in a jury as does any other citizen. I'll mention in passing that I do agree, I think, with the Labour Party minority report that suggested that perhaps we need a sort of a second chance provision for people, particularly over the age of 65, who have chosen to take the permanent excusal route, but who might think better of it. I mean, one can easily imagine a person in their mid-late 60s perhaps suffering a spate of ill health or some other life event that really doesn't put them in a mind to sit on a jury, who might take this permanent excusal road, but then live to regret it some short time later, or some year or two later, might wish to participate again. And I think it might be helpful to consider at the committee stage an amendment that might allow a person to take back the right to be a participant on basis of age or disability, whatever it might be. I suggest that sort of the opportunity to change one's mind might be something that wouldn't routinely or often be exercised, but I think it would do the amendment no harm to at least make provision for that, for somebody simply to change their mind, for their situation to change, for their health to improve, whatever it might be, to allow them a second chance at this participation in a very important civil service. So I think the second part of the bill, or the second major part of the bill at least, talks about protecting the jurors' personal details, their address and other details. And Mr Goff has quite clearly articulated the difficulty with endeavouring to make jurors' details absolutely secret. In one sense, it's not desirable that people should feel the need for absolute secrecy. It is, after all, a jury of one's peers. People should be able to stand or sit on a jury with a degree of security, knowing that it will not cause any ill effect to them. There was, however, this one instance where a person defending themselves did get the opportunity to cause some discomfort to members of a jury when he was able to write to them directly at their home address. That could give people considerable cause for concern, and quite legitimately so. So to the extent that this bill does endeavour to put in place another layer of security, another layer of protection for people whose details might otherwise be readily available, that's something we can quite happily support. Though again, it is only a partial remedy, and I'm not sure any of us could come up with an absolute ideal outcome for any of this. So I think, in passing, that there are things that this bill does not address, which it could usefully address, and one of those would be compensation for jurors. I did once serve on a jury, and at that time I had the luxury of an academic salary. I was able to sit on a jury for some 5 or 6 working days and suffer no material cost. I think there was $20 or something, and one's bus fare was provided. To me, it was irrelevant. I was in a situation where I was able to participate. That is not the case for people who might be working part-time, working on an hourly rate. People who, I think as a general principle, people ought not to suffer any material disadvantage or loss through serving on a jury. And I think it's unfortunate that the opportunity was not taken in this bill to address that very real difficulty, particularly for people on low incomes, on fixed incomes, or people who don't have the luxury, as I said, of a salary or a secure financial background. So with those slight reservations, sir, we are nevertheless supporting this bill and will continue to do so. Thank you.
Call Jamie Lee Ross.
Mr Speaker, we seem to be